SJC-12575, Commonwealth v. Denisha Newberry.
Mr. Zanini.
Good morning, Chief Justice, Justices of the Supreme Judicial Court.
Injured again.
Still injured.
Okay.
May it please the Court, John Zanini for the Commonwealth. There are three questions before the Court in this case: whether the statute requires arraignment when the district attorney moves for arraignment, whether the proper diversion process was followed as applied to this defendant under the statute, and whether the judge can order conditions of release such as GPS monitoring by the probation department without having arraigned a person. At the outset, I want to say there's the legislative concern for allowing diversion for people who commit non-assaultive offenses is well recognized. There was a comprehensive amendment of the Criminal Justice Reform Act in 2018 in a couple of different parts that implemented in 11 different places, or sort of animated the concerns and recognized the concerns for avoiding criminal records. I would suggest the critical guiding principle here is that as to the words "at arraignment," where the legislature has employed specific language in one section of an act but not another, the language should not be implied where it is not present, and that the statute has to be read in a way to give it a sensible meaning. That's from the Dodge case, that this court applied those principles and regularly does so. As to the particular phrase "at arraignment," there are two places in the reform bill that really inform what "at arraignment" means, and there are 8 other parts of the criminal reform bill that reflect on what "at arraignment" means in terms of protecting people from criminal records. I'll start with the first 3, which is for juveniles, unlike adults, the legislature explicitly said that the case shall not be arraigned when it's being diverted. So that is clear, it is explicit, the legislature knows exactly how to say that and did not say it with respect to all of the adults under the adult diversion scheme. Secondly, there is the use of the phrase...
In the juvenile, I've got them in front of me too. So in the juvenile one, they use prior to arraignment multiple times. I get that part. The other ones, though, don't use that formulation. The Valor statute only uses prior to, the "at" or "prior to" language in terms of determining whether you're a veteran or not, right?
Correctly. So the "prior to" is just what the probation department does when they're doing their little eligibility checklist, is to say, okay, are you a veteran, and do you previously have criminal conviction? Do you have a current continuance? Do you have a current criminal case? And of course, the only way to know if there's a current continuance, even for diversionary purposes, or a current criminal case, is to actually arraign the person and have an entry in the court activity record information system. Otherwise, those continuances and prior criminal cases that may be ongoing, although diverted, are essentially invisible. And so statewide, the way that...
That's a separate issue. I just want to stick to the statutory interpretation first.
Right, but I think
Right.
the interpretation has to be informed by the reality on the ground of the way the entire system works.
If I could ask you to explore that a little bit. Ms. Newberry was out for many months. What happens in terms of what record, if any, is made of the fact that there is this case, if it's not to be an arraignment and a carry record?
I believe the only place you would see it is in the mass court system, if you can see the mass court system. However, the mass court system does not allow, as far as I can tell, because I've tried, I can't do a search by name and figure out whether someone appeared in court in Pittsfield or in Weymouth on a case, or in Essex on a case using mass courts. The carry system is the internal system that is available only to probation, judge, prosecutor, defense lawyer. It is not an external system. It is not a public system. The information on carry does not become public. The Corey system is public, and in this comprehensive reform bill, the legislature explicitly addressed the Corey system and diversion, and said that if you are successfly diverted and your case is dismissed, then you can have it sealed. And when it's sealed, when you're asked a question about employment or housing or I think government employment, you can explicitly say no record. So the protection of the animating concern to protect people against a criminal record that the legislature has and that the court recognized in Morgan is protected by this comprehensive scheme. The other place, back to Justice Kafker's question, where the particular use of the words pre-arraignment were actually used by the legislature in the Acts of 2018, Chapter 269, Section 18. So pre-arraignment in relation to diversion is in the statutory scheme. It amends Chapter 12, Section 34, which is the district attorney's part of the laws. And it says that the DA shall establish pre-arraignment diversion programs for veterans, mentally ill, and substance abuse disorder people, but that the DA may divert that person. So the only time a pre-arraignment diversion will happen, and that's a very explicit phrase, pre-arraignment, is when the district attorney may do it. That explicitly recognizes separation of powers and clearly says pre-arraignment. The legislature did not explicitly use that phrase for all adults or in the general diversion section, so the court cannot apply it or imply it and should not imply it in that provision. As part of the overall statutory scheme, there were multiple other parts that I should just...
They don't use the word after arraignment, right? They could,
Correct.
They could have easily clarified this point, and we'd all be home free, right?
But we are home free because they didn't use it. So you can't imply the word after.
Why? I mean, at arraignment it's a proceeding, right? You're at arraignment.
Yes.
And what's that, you're talking about the order of things there, and it seems inconsistent with the idea that you're trying to not create a record and allow an ability. I mean, you can divert. Obviously, if the DA does its diversionary program, we don't have an arraignment, we don't have a record. And if the Essex DA does it, you don't know about that, right?
We would have to specifically inquire, that's
So
correct.
So all that world works when you have control over it, right?
Well, that is explicitly the executive authority.
No, I'm not
yes.
disagreeing that there's a separation of powers issue, but the world works pre-arraignment or just fine as long as it's under your control. It's when it's out of your control that this becomes a problem, right?
Well, I wouldn't say it's a problem. I would say the legislature recognized the separation of powers concern, and in terms of not having a record, explicitly created a method for sealing it and for answering in response to particular questions. There is no record.
But the problems are constitutional in your view, and the other record-keeping problem doesn't seem to be that big a deal because it's, as long as it's a DA diversion program, we don't have a Rule 36 starting date or anything else, right?
Correct, and part of that, but that goes back to other parts of the statutory scheme, and as you say, at arraignment. At arraignment is a process, so even the court's understanding of at arraignment can be informed quickly and easily in three places. Mass Rule Criminal Procedure 7, District and Municipal Court Rule 3, and the Standing Order 2-86 of the Superior Court. So Rule 7, which applies to all courts, at arraignment, you read the charges, enter a plea, inform of all warnings and advisories, determine the conditions of release, which I suggest include diversionary programs when appropriate, assign counsel. Under Rule 3 for the District and Municipal Court, you get a copy of the police report. You do everything in Rule 7. You also get a copy of the police report to defense counsel. You get a notice of probation violation. The court either enters a probable cause hearing date if it's not in the final jurisdiction of the court, or a pretrial hearing date if it is in the jurisdiction of the court. All of those things happen at arraignment. And under Superior Court tracking rule, of course, you get on your track and you get your dates, including your trial date, and you do that at arraignment. There's no reason to do any of those things at arraignment unless you're actually at the bar tendering a plea. And that's why the statute also includes explicitly a provision that the defendant represented by counsel with the advice of counsel, must voluntarily consent to and waive in writing their speedy trial rights. There's no reason to waive any speedy trial rights unless you've actually been put at the bar, tendered a plea, and that clock starts running. So that is part of this comprehensive statute.
If I can, so what I understand you to be arguing is that there exists pre-arraignment diversion, but that essentially is a prosecutorial function.
Explicitly, yes.
That when there is pretrial diversion, there is an arraignment.
When you're proceeding to divert and send a person to a defined program to benefit the public and to protect the public and benefit the individual in a program as defined in the statute, and come up with a plan of services that if the DA moves for arraignment, you arraign the person.
Okay, but now, I was unclear from your brief. At one point, you say, if we were to find that Ms. Newberry should be arraigned, then the constitutional issue goes away. But then you go further and say you'd like us to go further and say that the legislature does not have any authority, even after arraignment, to permit a judge without the approval of the prosecutor to dismiss a case.
Not no authority. So the rules around dismissal have been pretty clearly articulated, and there was a long stretch when there was a Brandano which gave rise to dismissal, and there were 25 years of Brandano and a lot of litigation, and ultimately the court said, you're right, in order to dismiss a case, the legal basis for dismissal set forth for a judge to dismiss a case is fairly discrete. And so what you have is a lack of probable cause, you have impairment of the integrity of the grand jury, or you have the deprivation of the ability to get a fair trial, typically by police or prosecutor misconduct. And the other occasion is as a disposition. But the sort of disposition you have, which is also referenced in this statute, is a continuance without a finding. So you get an admission to sufficient facts, you get a continuance without a finding, including under this statute, as part of this statute, and you get conditions imposed. And if the person succeeds, at the end of that, because the person has admitted that they've done the acts and is getting a disposition, you get a dismissal. But short of that, you don't get a dismissal when you have a valid pending complaint or indictment. And the other reason why the legislature recognizes that, I suggest, in this statute, is because they explicitly say, of course, if a district court judge dismisses it over the objection of the Commonwealth, presumably over the objection without the consent or agreement, you can indict the case. Well, if you're indicting the case, it's because there was no prejudicial dismissal, prejudicial to the Commonwealth. So there's an explicit recognition that the district attorney, if the district attorney doesn't agree to the diversion ultimately resulting in dismissal and doesn't agree that there was success, that the DA can go indict this person.
Mr. Zanini, I understand that you believe that Commonwealth versus Morgan was decided incorrectly, but let's say that we reaffirm that. The at or prior to arraignment, the Valor Act, how do you think the Valor Act informs this decision? Because we don't have the prior to arraignment that we do with the DA diversion. We don't have the prior to arraignment that we have with juvenile diversion. So the Valor Act.
Yes, I don't think, as I reread Morgan, I don't think that explicitly before the court, I may have missed it, was the question of whether the person actually gets arraigned. Mm-hmm. What the court was doing was saying that, like young adults who are 18 to 21, veterans, the intent of the legislature was to treat veterans like young adults to provide diversion to avoid the permanent record. The legislature took Morgan into account when they wrote the criminal reform bill and took it into account, and I believe also took into account the district attorneys sort of voicing the concern that the separation of powers had been violated. And I believe they took it into account in the criminal reform bill. And they explicitly included veterans now under Section 4 of the bill. They removed the age limit of 18 to 21. They have provided for much easier sealing, and when it's sealed, you get to say no record. But again, they've excluded indictments, they've required a written waiver of speedy trial rights, and they've established also restorative justice. So I think the legislature looked at Morgan, heard the DA's complaints or concerns about the separation of powers, which were not out publicly aired, but clearly were part of the considerations, and came up with a comprehensive scheme, the legislature balancing the public interest and the need to have records, the need to decide who gets diverted and do it accurately in the future, the need to protect people from their criminal records, and came up with a comprehensive scheme.
That comprehensive scheme means that if you receive a quaff, whether it's on the DA, well, if you receive a quaff, say under the Valor Act, for instance, or under the 2018 Act,
Yes.
that public record is unavailable.
Correct. If you
After you go through the probationary period and it's dismissed.
Correct. So they've actually provided even more benefit in terms of the quaff resulting in dismissal.
Right.
Unless the court has other questions, I will leave the case to the briefing. Thank you.
Thank you. Ms. Joss? I think Ms. Joss goes second, at least according to my schedule. And Ms. Joss, you've got 5 minutes on behalf of probation.
Thank you, Your Honor. Good morning, Justices of the Supreme Judicial Court. Sarah Joss on behalf of the Massachusetts Probation Service, and with me is my colleague, Nikisha Davidson. Probation takes no position on the question of whether or not a diversion under 276A can occur prior to arraignment over the objection of the Commonwealth. Probation simply seeks to address the issue of whether or not there can be an invocation of the machinery of probation in such a circumstance if the court were to find that 276A did allow for pre-arraignment diversion. The reason that there would
Say
be...
that you mean pre-arraignment diversion without agreement by the Commonwealth?
Correct.
Right, okay.
Well, pre-arraignment diversion, whether it's the version where it never comes to court and the district attorney simply diverts before the person ever comes in, or pre-arraignment diversion where the person comes into court and the court says, we're not going to arraign, but we're going to divert you. And obviously that question is an open one and for the parties to address, but probation needs to address the issue of the invocation of the machinery of probation if the court were to say that 276A did permit a pre-arraignment diversion.
What happens if there's a clerk's hearing and the clerk magistrate decides that there's probable cause but decides to continue the matter? And there are conditions for that. Does probation ever have any involvement in that?
None. Those are purely between the parties and the clerk. Probation does not get involved other than certain statutorily designated roles prior to arraignment. Those roles are the screening for diversion, whether it be valor or other, the screening for indigency, and the screening for substance use under Chapter 111E. And the reason that there would
Ask
be...
you a historic question. I know Judge, Mr. Zanini was then there back then, but Rule 7 was changed, right? So prior to 2012, Rule 7 provided that the initial appearance in the arraignment had 2 separate events. I don't know if you date back then, but
I do.
prior to that, the condition of relief was set at the defendant's initial appearance. I'm just citing Commonwealth versus Butler, 423 Mass. at 523, quote, "When the defendant is presented to the court, Rule 7 requires the court to determine whether the defendant is indigent and if eligible to assign counsel to the defendant. In addition, at presentment, the court must either arraign the defendant or set a time for arraignment and determine the conditions of the defendant's release." So back in the old days, you would determine this right before arraignment.
I think the rule contemplated that there could be 2 different appearances, the initial appearance and the arraignment, but I think the case law basically said that they didn't have to occur separately. And I think that when you think about what the case law says, specifically Dodge, that the court lacks the inherent authority to set conditions of release, that is purely statutory, and I don't know why Rule 7 was amended, but I think that Rule 7 as it currently exists is more consonant with the case law and the bail statutes.
But if they did it in the old days before arraignment, was that sort of an extra legal act?
It may not have involved probation at that point. It could be more akin to what happens in a clerk's hearing, that there simply isn't an involvement by probation. And so if we look at, I think, 3 reasons that you would not have probation involved prior to arraignment. 1, it's contrary to statute. Nothing in the bail statutes permits the involvement of probation prior to an arraignment. Second, that this court in Dodge specifically found that where the statutory scheme set forward in the bail statutes covers the ability for the court to set conditions, that the court lacks the inherent authority to set conditions of release. And that's consonant with Jackson, where the court found that there is no inherent authority for probation. And finally, that the involvement of probation prior to an arraignment actually flies significantly in the face of all the research about the appropriate deployment of probationary resources, specifically.
Please finish your answer, I apologize.
Thank you, Your Honor. Specifically that involvement and over-supervising of individuals at low risk to reoffend actually increases their chances of recidivism while simultaneously pulling resources away from the supervision of individuals at high risk to recidivate, thereby increasing their chances of recidivism, meaning that that mismatch of resources and that pulling away of resources from the high-risk individuals means that we now have a double hit to recidivism reduction efforts. Justice Lowy, sorry.
Yes, no, thank you. Yeah, so I understand point 1 and 3, and point 3 is important and well taken as a matter of policy. But on number 2, as far as authority goes, putting aside this, there was a statute to address the limitations of Dodge as it relates to Section 58. There's also, there can be conditions of release if under pretrial probation if both sides agree, though.
And that would be after an arraignment, that would still be under Section 87 where the parties agree, but that would still be after an arraignment in order to involve probation.
Right, as it relates to factor number 2 with Dodge about the authority.
And there were amendments to address that, and I would suggest that what happened with the amendments is that the legislature, recognizing the court's decision in Dodge, meant that under Section, I think it was 58, there wasn't that ability. Mm-hmm. What the legislature did was give the court that ability after arraignment to set those conditions.
If I could ask you a question, I asked Mr. Zanini, what records are there of this case?
I think that's a tricky question, Your Honor. There is, as Attorney Zanini pointed out, there is no carry. As this court noted in Humberto H., carry starts at arraignment. Carry feeds the quarry. So there would not be a public-facing record of any pre-arraignment diversions. I think Attorney Zanini is correct that it would be recorded in mass courts on the clerk's side, which is the case management software, but that's not something, to my understanding, that would be publicly accessible.
So there exists some document in mass courts that says this case exists.
Yes.
But it's in mass courts, not in carry.
Exactly.
And probation, I guess, has access to mass courts.
We do.
Okay. Thank you.
Thank you, Your Honors.
Ms. Stanton-Flaherty?
Good morning, Your Honors. Good morning, Chief Justice. May it please the court. The common practice of referring a defendant to pretrial diversion prior to arraignment is well within the authority of a trial court judge. Both the language and the purpose of the statute are consistent with this common practice. In terms of the purpose of the statute, as you know, was enacted in 1974, and the purpose of the statute was to target individuals whose criminal habits have not yet been fixed. People with no prior convictions. At the time, it was for young people, people between the ages of 18 and people who have not yet reached their 22nd birthday. Recently, the legislature amended that to remove the age restriction. And currently, it is available to any adult, an adult of any age that fits within the parameters of the statute. The purpose of the statute was to provide people with rehabilitation and access to services so that they don't have a criminal record and they don't have the collateral consequences that come with a criminal record.
So all of that is really important, a little bit of an understatement, But the issue for us is who makes that decision.
Yes, Your Honor, and I believe the statute 276A gives the authority to a trial judge. There is no issue of a separation of powers here because there is a statute. And that's consistent with the Morgan case, the Guzman case, the Piles case, and even Newton N case. Because there's a statute, because the legislature, in their broad authority to act, their broad authority to define criminal conduct and tell us what the penalties are, gave judges the authority to act here.
We need to interpret what they meant by at arraignment, and we've got to look at it in context. One important tool we have to look at is the purpose, as you just argued, that sensibly would be defeated if an arraignment happens. But when we look at the statute, it says, as this proceeding chugs along, there's a right to speedy trial waiver that has to be signed by the defendant, right?
Yes, Your Honor. The statute does say that, and I did see...
And what Mrs. Zanini argues, and what I'm curious about, is why is there a need to waive the right to speedy trial if the clock hasn't started with an arraignment?
Yes, Your Honor. Well, in terms of the speedy trial, Rule 36 would exclude any time that was at the motion of the defendant. So practically speaking...
But that would start
That's
after
at
arraignment.
The Rule 36 clock starts at arraignment, so why is there a need to waive it?
Well, Your Honor, I think importantly, I think that the at arraignment is the day of arraignment. I don't think it's when arraignment is completed. I think that, Your Honor, the language of the statute is very clear, that it
Okay,
says...
but is that just, you're not really answering my question. Why is a waiver needed if Rule 36 hasn't started? Is that language something that just we should ignore that's in the statute?
No, Your Honor, I don't think that we should ignore that language. But I would submit to the court that as a defense attorney, I would not be able to file a motion for speedy trial based on the time period that I had requested this continuance. I don't think that I would be successful in a speedy trial motion. And I would submit to the court that at arraignment does not mean after arraignment, and that if the legislature meant after arraignment, they would have specifically put that in the statute.
Well, you can also argue that they could have also said prior to arraignment if they meant that. And here's my concern. My concern is that when you take away the executive branch prerogative, you being the legislature, takes away the executive branch prerogative to make a decision about whether to go forward with a prosecution or not, the language that I would hope would be there would be pretty clear. That's a big deal to say that it's not going to be the executive branch that's going to make this decision about whether or not the prosecution can go forward. And I'd be a lot more comfortable with prior to arraignment.
Yes, Your Honor. And I would argue to the court today that if a statute is ambiguous, if it's not extremely clear, as Justice Lowy mentioned, it does not say prior to and it does not say after, then a statute should be interpreted in a manner that advances the objective of the statute. And the objective of the statute is to target people whose criminal behavior has not yet been fixed, people that don't have prior criminal convictions.
Can I make sure I
and to
understand
preserve them.
are you saying the judge can decide one way or the other? So each judge has the ability, he or her can decide that, whether it's pre-arraignment or post-arraignment?
Yes, Your Honor. I would say that it's at the discretion of the judge.
Isn't that a little problematic, though? So each judge gets to decide whether to create the record or not based on what standard?
Your Honor, I would argue that 276A, the exact language of the statute, gives judges a great deal of discretion. It says that the prosecutor's opinion and recommendation must be taken into account.
That's for the diversion program itself, right? Not
Yes, Your
whether
Honor.
it's prior to or after arraignment. I just was trying to figure out what the standard was going to be if you're right, and it's a discretionary call. It's just an open-ended abuse of discretion, whether it serves the purposes of diversion to create a record or not create a record. Isn't it, in your view, it always serves the purpose not to create a record?
Certainly, as a defense attorney, Your Honor, I would always prefer not to create a record for an individual. However, I do recognize that there are certain circumstances where a judge would be inclined to create a record. The common practice also in the district or municipal court, certain cases are dismissed prior to arraignment. Certain cases are arraigned and then dismissed. I think that it would be a case-by-case basis in terms of the facts before the court and the individual before the court.
But this statute does something in addition to that, that nobody is contesting, which is another option. Now, under the statute, there can be an admission of sufficient facts, a continuance without a finding, and also there's no available record. And that seems to be important and argue against why there's the need for the judge unilaterally to be able to say, absent explicit statutory language, okay, I'm going to make the decision whether or not this prosecution goes forward or not. So why doesn't the availability of the quaff and the dismissal that was always available, but now it not showing up on Corey, on Carey, satisfy that concern that you just raised?
Well, Your Honor, I think that even without a pretrial diversion program, a quaff and a dismissal is available to people that fit this class of people. Right. Your Honor, so basically, if I can back up, the pretrial diversion statute is very limited in that we're talking about people that do not have prior criminal convictions. And recently, the legislature limited the types of crimes that fit into pretrial diversion. So we're talking about the most minor offenses, such as trespassing, possession, straight possession of a controlled substance, simple assault and battery where there's no injury or no weapon. So to find someone who's actually eligible for pretrial diversion is not easy.
Yeah, I guess my point is much simpler than that. You're making all these compelling arguments of why it's important not to have somebody burdened with no prior record and an offense that isn't a major offense. And what I'm saying is that where we're dealing with an Article 30 issue, where that can all be accomplished after arraignment, and where we don't have the prior to arraignment language, doesn't that help us interpret what at arraignment means?
Well, Your Honor, I did notice in the Corey law, certain offenses are available to people, to many people. So any pending case is available to an employer, to a landlord, to a housing authority, or to a licensing authority. So if there is a pending case, even a continued without a finding that has not yet been dismissed, that would be available.
Under this act?
Even under this act. So a pending case would be available.
All right, well, that answers my question.
Yes, Your Honor. And also in terms of that, for things like a Section 8 application, so if someone was applying for Section 8, someone was trying to get housing under a Section 8 voucher, if they ran a query and saw a pending case, that would be red flagged. Section 8 is not supposed to disqualify someone just because they have a police report and arrest, but they can disqualify someone for the underlying conduct in a police report. So something like that, they would have a hearing, they would have an opportunity to be heard, but it's possible that someone could be disqualified for a Section 8 voucher because of an open case.
How do you address the problem with, multiple bites at the apple if there's no record keeping?
Yes, Your Honor. I would say that for a few reasons. The first is that it seems that this is already happening in the juvenile context of the law, and the record keeping does not seem to be a problem there. The record keeping could be done internally by the district attorney's office, also by the probation office, and also by the clerk's office. In the instant matter, there is a docket number, and it's also by last name. So you could go to the clerk's counter at Roxbury Court with the docket number. You could pull the file, and you could read the docket sheet and see that Ms. Newberry was on pretrial diversion.
But if I'm a judge in Brockton and she comes before me, I'm not going to know whether or not she had this procedure, right?
That's true, Your Honor. You would not know. I guess that you could look at mass courts and see that.
I'm just going to ask, they're going to tell me she's got no record. We're good to go. That's what's going to happen, boots on the ground, right?
It could happen. Yes, Your Honor, it could. But I would submit to the court that it would be, again, the class of people that qualify for pretrial diversion are so small. And it's these very minor offenses, someone without prior criminal convictions. The chances of this happening, that someone would continually get a second bite at the apple or a third bite, for someone whose criminal habits are not fixed, I think that it probably would not happen very often, if at all.
Can I shift you to some of the other issues that this presents? So here we have, after 14 days, we get back a letter from the hospital, but it doesn't really comply with the statute, right?
Well, I would argue, Your Honor, that Ms. Newberry did everything that probation asked her to do. She met with probation after her first day at arraignment. She went downstairs and met with probation. She was screened. She was told that she was eligible for pretrial diversion. She was told to go to counseling and bring a letter to court on the next day. That's what she was told to do.
But the statutory requirement is, all she did was schedule an appointment, right? The statutory requirement is, it may be a totally unrealistic statutory requirement, but it talks about basically an evaluation of whether you're a suitable candidate for this, right?
Yes, Your Honor.
That didn't happen, right?
Well, what did happen, I guess maybe I would argue that the statutory requirement is not realistic in that sense. It's not practical.
Right.
What Ms. Newberry did is what exactly she was asked to do, is to begin counseling, to make contact with the program.
Okay, but let me just take this, because I'm worried, and I'm going to circle back to the arraignment point, because each time it gets kind of mushy what happens, right? They request a 90-day continuance, right? That happens. In the meantime, there's an issue of whether she's violated the terms, because she may have harassed the girlfriend, right? Then nothing happens. So we have no docketing of anything during all of this. It's all a mystery, right? And is that a problem, that this thing, without an arraignment, it's kind of in its own little air bubble that just floats above the court system?
I don't think so, Your Honor, because as I said, there is a docket number, there is a docket sheet. She had 5 court dates before the court. She was before the court. She was there under this statute. Everything is docketed, everything is shown that she was screened for eligibility. She had the 14-day continuance. She showed contact. Then she went and actually did the counseling. And after her 90-day date, came to court with letters to prove that she did her counseling. And at that time, that's when the Commonwealth alleged, not that there was any problem with the counseling, that has never been raised in the lower court, but that she violated the second term of her pretrial diversion, which was made contact with
Counsel,
the alleged victim.
I have one question that might not appear relevant, but in the event that the district attorney decided they wanted to put somebody in pretrial diversion and they go through their process, would the judge, does the judge have to accept that?
I'm sorry, Your Honor,
If the district attorney wanted to go through the district attorney's process for pretrial diversion, or through the process and come into court and say, we want to put this person on pretrial diversion, does the judge have to accept that from the Commonwealth, or could the judge override that and say no?
And, Your Honor, would that be with the 276A? I would think that the judge has discretion, that the judge can do, since it's the judge's courtroom, it's the judge's discretion, that the judge, if for whatever reason they feel this person would not be a proper candidate for pretrial diversion, that they could decline to enroll them in the program. In Your Honors, if I may, just in terms of the GPS, I would submit to the court that the justices of the Roxbury Court had the authority to place pretrial conditions and the GPS on Ms. Newberry because she was before the court.
Can you, if you were writing their decisions, what would you cite for that proposition?
Your Honor, I would cite to the proposition that,
I was hoping a case or a statute as
Yes.
opposed to a principle.
yes, Your Honor. So I would cite to the cases that I mentioned in my brief, which are the Chief Justice of the Trial Court, the Mass Probation Association case, and the First Justice of Bristol County case. Those were all mentioned in my brief. And basically, they state that a probation officer is an employee of the judiciary, that a judge must have the power to control his courtroom, to be able to supervise the people in the courtroom, and that in this case, Ms. Newberry was before the court. She was required to be in court. If she ever missed any of those court dates, a warrant could have been issued for her arrest. So the fact that she was not arraigned is not really the bright line to show that the court proceedings had started. They had started. And just like in the Torres case, a person is entitled to appointment of counsel prior to arraignment. A person is entitled to an attorney when they feel, when the prosecution has begun, when they are immersed in criminal prosecution, even if an arraignment has not occurred. And that's similar to this case.
So what records is probation to keep if probation is to be engaged in the case?
Your Honor, I would argue that they would keep the screening, the initial screening, and keep track of, whether or not this person did complete the program as required, and the fact that she has been diverted to pretrial diversion.
All right, thank you.
Thank you, Your Honors.
We'll take our morning break.